Hey friends, I'm Chuck Slemp, Commonwealth's attorney for Wise County and the City of Norton.
And I'm Ken Lammers, Assistant Commonwealth Attorney for Wise County and the City of Norton. And we're here today to do the legal update for the special session from 2020, because those are going to into effect in large part on March the 1st.
As always, before we get started with the presentation today, if you have a question, feel free to call either of us or anyone in our office. Our email address as well is on the screen. If you have specific questions, don't hesitate to call.
And that said, let's get started.
This recording is going to go through some of the most relevant legislation that affects you and law enforcement from the 2020 special session of the Virginia General Assembly. That special session was called at the end of last year to focus on criminal justice reform. This presentation hopefully will help educate you on what's relevant and what's coming. So last year, Ken did a great update during the summer of the new laws that took effect on July 1st, 2020. And the General Assembly, during its last session in 2020, passed a lot of criminal justice reform bills, taking us from a tough on crime to a reform mindset. And those reforms included everything from marijuana decriminalization to increasing the larceny threshold to requiring audio video police custodial interrogations, gun control measures, etc. On July 17th, 2020, after everything had just taken effect from the 2020 regular session, Governor Northam called for a special session. And that was called in the wake of the George Floyd killing in Minneapolis and all the protests and everything that followed. They convened the special session virtually on August the 18th, and it lasted for 12 weeks.
The reason we're doing this today is because these changes will go into effect primarily on March the 1st, which is shortly upon us. And there are some things that will go in July 1st, but most of the things we're talking about are going to hit, well, Monday. So you need to know them now. The first thing we're going to talk about is the use of force. And Chuck wanted me to make sure that everybody knew it wasn't that kind of force. The General Assembly has very clearly laid out that they are interested in making sure that officers do not use deadly force unless they have to. And they put statutes in place to forward this goal. As we see here, law enforcement must reasonably believe that deadly force is immediately necessary to protect themselves or another person, but not the person who they're going to be using the force against, from serious bodily injury or death. They have to first provide a warning if they can, so that, telling the person they're going to use deadly force, and their actions have to be reasonable given the totality of the circumstances, and all other options have to be exhausted or not reasonably lend themselves to the circumstances. Now, this does not mean that an officer has to create circumstances, to exhaust before he can move to deadly force in appropriate circumstances. Say someone turns to the officer with a gun drawn and starts shooting at that officer in the open. The officer will then be justified without having to try to exhaust any kind of other, behaviors, options. He'd be justified, because he doesn't have any other options, to use deadly force at that point. Now, of course, the question is going to be, what's deadly force mean exactly? And the statute has laid out a couple factors for deadly force. Well, several factors, but they're broken down into two general areas. The first is reasonableness of the law enforcement officer's belief in his actions from the perspective of a reasonable law enforcement officer on the scene at the time of the incident. In other words, if all law enforcement officers, the majority of law enforcement officers, would have reacted the same sort of way with the same sort of information, then that's a factor strongly in favor of the reaction of the law enforcement officer. The second thing, though, is going to be totality of the circumstances. And that's going to include a number of things, to include the amount of time the law enforcement officer has to make a decision. somebody turns immediately on a law enforcement officer and starts shooting at him or charging him, that's going to be different than someone who's barricaded themselves in a house and refuses to come out, obviously. Now, it's going to be whether or not the person who's subject to the use of deadly force has a weapon, deadly weapon, whether he's refused to lay that weapon down or what's perceived to be a weapon down before the officer used deadly force. There's going to be a question whether the officer tried to de-escalate the situation. There's another emphasis the General Assembly's been involved, very serious about this year, is de-escalating situations. The things that they look towards to see whether the officer tried to de-escalate is, did he try to take cover? Did he wait for backup? Did he try to calm the subject down before he had to use deadly force? Or did he try to use any other kind of non-deadly force first? And if we go further, whether the conduct of the law enforcement officer purposefully increased the chance of a deadly confrontation taking place. And of course, the seriousness of the crime being involved. So if an officer pulls somebody over because they suspected him of shoplifting, that's going to be dealt with differently than if the officer pulls someone over suspecting that they have just taken part in a bank robbery.
Now, there are specific instances that the General Assembly has said these are prohibited conduct by police officers. A lot of the things that we've just covered that are now codified in statute have really not changed over the years, and it's pretty much existing law now. But these are specific things that the General Assembly is changing, and one of those is the willful discharge of a firearm by an officer into or at a moving vehicle is prohibited unless the discharge of that firearm is actually necessary to protect a law enforcement officer or another person based upon a serious injury or possibly death. There are other specifically prohibited items. For instance, police can't use rubber bullets, right? These kinetic impact munitions to fire on someone to stop whatever activity. Further, there is now a prohibition on the term neck restraints. And neck restraints is actually prohibited by statute and defined by the code. As you're seeing on your screen here, it's the use of any body part or object to attempt to control or disable a person by applying pressure against the neck, including the trachea or carotid artery, with the purpose and intent of controlling or restricting that particular person's movements. Basically, the rule is the use of a neck restraint by law enforcement officers are prohibited, unless that neck restraint is immediately necessary to protect the law enforcement officer or another person from imminent death or serious bodily injury. The penalty for violating that provision is, in addition to everything else already prohibited by law, the law enforcement officer who knowingly violates that provisions of this particular chapter can be subject to disciplinary action, including dismissal, demotion, suspension, or even transfer.
Another thing that the General Assembly has brought forward, obviously for reasons that we've all seen on TV over the last year, is a duty to intervene by officers who see another officer engaging in excessive force against a person. So they are now making a duty of every officer to intervene, specifically intervene whenever they see a fellow officer, for instance, having made neck restraints non-legal. An officer might have to intervene if he sees another officer using them inappropriately. If that officer does this, they have a duty to report to their department that it has taken place, and the department cannot take any disciplinary action against an officer who does their duty under this statute.
So, additional restrictions on law enforcement and police activity is a restriction on police equipment. Ken's tank here, for instance. It prohibits law enforcement from purchasing or employing various types of, we're using the term military grade equipment, although it's not specifically defined as that in the code. They do specifically list certain exceptions, or certain, not exceptions, but certain requirements here. No weaponized unmanned aerial vehicles, for instance, bayonets or hand grenades can't be used, firearms of a particular caliber, ammunition of a particular caliber, or even weaponized track armored vehicles, tanks, etc. One of the big areas that the General Assembly changed was your limitation to stop individuals, the limitation of law enforcement's authority to stop individuals for various traffic offenses.
Okay, they created a list of things which you cannot stop somebody for. And generally, if you stop a motorcycle, moped, motorized skateboard, or scooter for violation of these sections, they've all become secondary offenses, right? So it would be a built-in defense that you weren't allowed to stop them for this. And B, anything you discover that comes from any of these kind of stops, and several of them even say, even if afterwards they consent to the search, it's not going to be allowed in a Virginia courtroom. Under Virginia law, it's just not going to be allowed anymore.
So Ken here on his hightail motorcycle here, I know he's making a lot of noise, living dangerously. You might not be able to stop Ken just because of the noise. There's a whole list of these things here, and we're going to go through them one by one, right, Ken?
Yeah, we're going to go through them one by one, and then there's certain ones we're going to go through more in depth afterwards. So I'll run through the list, and then we'll let Chuck start the next one. It's actually have some meat to it. So motorcycles, mopeds, and scooter noise, you can't stop for that. You can't stop for marijuana smell. You can't stop odor. You can't stop because they're outside their license restrictions for some. You can't stop someone for being outside their restrictions on a learner's permit. You can't stop somebody for expired registration. There's some exceptions to that. We will get that in a bit. You can't stop anybody for smoking in a vehicle with a minor, anybody under the age 15. You cannot stop someone for jaywalking across the street. You cannot, and in my opinion, that basically writes the jaywalking statute out of the books. I don't know why they didn't just take it out, but you can't stop anybody for it. You can't stop anybody for defective equipment. They've also changed that statute a little bit. We'll get back to that in a minute. You can't stop them because the taillights are out, brake lights are out, although some exceptions we'll cover. You can't stop them because the supplemental high mount stoplight is out. That one at the top middle of your back windshield. You can't stop them for loud exhaust, window tinting. You can't stop them because something is suspended from the top of their car and
Dangling
might
objects.
obstruct their view. The dangling object thing, it's been going on for years, and they did change the standard on that to substantially obstructing as well. Occupants of front seats without safety belts, can't stop them. You can't stop them for expired inspection. There's exception to that. We'll come back to it. And you can't stop them for failing to follow a traffic sign.
So as we go in depth into a few of these, the requirement of 2 visible red taillights, that's one they took out. The requirement for a supplemental high mount stoplight, the improper window tinting, obstructed view. Ken mentioned the substantial obstruction language. There's also the non-working exhaust system that's mentioned, the noise from a motorcycle or something, a muffler system that's mentioned, driving outside the limits of your professional driver's permit and professional driver's permit while you have a learner's permit, using a cell phone or a wireless communications device. You might remember that they just made that a primary offense back last July. Well, now it moves to a secondary offense. Smoking with a child in the car, you may recall they made that a primary offense last July, and now they make it a secondary offense again, going backwards in time on that. And failure to wear a seatbelt as well. Now let's look at the specifics on the brake and tail light, Ken.
Okay, so no law enforcement officer shall stop a motor vehicle, trailer, semi-trailer, for violating it, except that a law enforcement officer may stop a vehicle if it displays no no brake lights that meet the requirements set forth in subsection A.
How confusing can you be?
Yeah, that can be all sorts of things. So A requires 2 brake lights of type approved by the superintendent that exhibit red or amber lights and can be seen at a distance of 500 feet, right? So what exactly do they mean, except if it displays no brake lights that meet the requirements in A? I think that may mean if both the lights are out, if they don't have it on the vehicle at all, or if for some reason they've got like purple and green brake lights instead of red and amber. There may be other exceptions, but those are kind of the ones that pop to my mind at the moment. And obviously, exclusionary rule applies to this. If you pull somebody over for it and it doesn't fit under that one bit there, nothing you find is going to be allowed in court.
That stop's going to be basically illegal. And they changed under the next section, the 46.2-1030, which talks about active headlights. So it's new under this section that no law enforcement officer can stop a motor vehicle for violating this section, that being the active headlights section. Except that law enforcement may, you can't, but you can, if it displays absolutely no headlights at certain periods of time. That's from sunset to sunrise, at nighttime basically. During the time when it's raining, or smoke, or fog, or sleet, or there's not enough light, unfavorable road conditions, okay, you can stop it then. Or whenever the windshield wipers are in use as a result of those conditions, then you can stop it. So the no headlights, you can't stop them because they don't have headlights on, unless you've got those restrictions. And the exclusionary rule applies to that as well.
Right. I would add here that the second one about atmospheric conditions, rain, smoke, whatever, it's a 500-foot test, right? So if they need the lights on to see beyond 500 feet, that's when you can pull them. And I think also with this, there's a whole lot of things about how many lights you can have on the front of your vehicle and that in this statute. And under this, as best I understand it, if they got 17 front headlights, you aren't able to pull them over.
Right.
So keep it in mind.
The defective equipment statute changed as well a little bit. It's now unlawful for anybody to use or have equipment on a motor vehicle operating on the motor highway, except as those things that are mentioned in 46.2-1002, that's defective and unsafe for the condition. The previous code section said or. No law enforcement officer can stop just based upon defective equipment, as the violation says in this particular section. And again, any evidence that you find as a result of pulling them over for defective equipment is going to be excluded and an illegal stop.
Now, let's say this, I think. Now, if the equipment is defective enough that it comes over into reckless driving, I think then you're solid on your stop, right? So
you got something hanging down and it's causing it to rub against the tire that it might break and pop the tire and wreck. Well, then you've got a cause to stop.
Right, or if somebody's got their tailpipes hanging and it's sparking so that it's throwing sparks on cars behind it. Something along those lines, you should be good.
Then finally, there was a whole lot of discussion here this session on the expired registration inspection sticker changes. There was a time that they were debating even eliminating the requirement to have an inspection sticker, a registration sticker at all. That didn't pass. But what did pass was that no law enforcement officer shall stop a motor vehicle because of an expired registration sticker if it's prior to the first day of the 4th month after the original expiration date. So that's confusing. So let's break that down, Ken.
Well, it basically means my registration runs out on the 1st of February. I've got 1st of March, 1st of April, 1st of May to get it back, right? 30 days. And then on day 1 of June,
you can stop.
You can stop me.
But not before that point.
Exactly.
Right. And if you do stop before that 4-month period, well, again, it's going to be an illegal stop, and any evidence that you seize from that stop is going to be excluded. Marijuana. is in the process of decriminalization. They decriminalized it last July. There's legislation at the General Assembly right now during the regular session of 2021 that would legalize marijuana, although that's not been signed by the governor. So let's not worry about that yet. What you do need to worry about is that no law enforcement officer can stop a vehicle, search, seize a person, place, thing, etc., just on the basis of the odor of marijuana itself. I know Ken touched on this during our last legal updates last summer because there was some questions about this, Ken.
Well, where we're at right now is obviously they left in 2 exceptions this time.
Right.
But basically, you're going to treat marijuana pretty much like it's cigarettes.
Right. There's some exceptions that we may not even see around here.
Right.
Right.
We don't, well, we have an airport here, a small one, but I don't think you're going to be running into too much of this. And if violation applies to the commercial vehicle, so you pull over a commercial vehicle and you smell marijuana in it, then you're still able to proceed.
Right.
But other than that, treat it like it's a cigarette, pretty much. I mean, yeah, if something comes up blatant enough that you see it on them, write them the citation, but you're not going to be able to proceed as though, say you smelled crack cocaine or something like that.
And we're going to have more legal updates this summer, I'm sure, when we talk more about marijuana. But that's all you need to know right now.
Okay, next we're at search warrants, and there have been some changes to search warrants. I don't really think these are going to affect the way we actually do things all that much, to be honest. I mean, I don't know what you think about it.
Right, the same. I mean, I know that these are restrictions. We need to follow them. We need to document them, but it really doesn't change how you do business on a daily basis. The biggest change, I guess, would be that you can't do a no-knock search warrant. I don't know how many of these that we do from time to time. I guess it might have been necessary, but no law enforcement officer can seek or execute or participate in a quote-unquote no-knock search warrant. That's a search warrant that you just bust in the door without knocking first. There are specific definitions and requirements of what it is that it is now required when you execute a search warrant. We're going to get into that in just a second. Under this section, the warrant section is requiring that law enforcement be recognizable, be identifiable in a uniform, and provide audible notice of your authority and your purpose of your search and the place to be searched before you bust in the door. There is a service requirement that's really not that different, Ken, from existing law, right?
This is pretty much the way we do it already.
After entering, you've got to find the occupant of that particular place, the owner, if the owner's around. If the owner's not around, then an occupant, and give it to them. And if there's no occupant there in the place that you're searching, well, then you have to affix it suitably to a place inside the location searched.
Now, it's not just give to them. Be careful here.
Right.
If you have an owner or occupant, you have to read it to them. Now, I don't think that means you have to read the affidavit,
right,
but you have to read them the search warrant itself.
It's got to be done in the daytime, Ken. Now, in the daytime is a broad discussion, right? We're going to talk about that in a second.
Yeah.
Quote unquote, in the daytime is the language of the original law. A judge or magistrate, if the judge is unavailable, can authorize you to do it outside of that daytime requirement. And the search, the other deal is if you're trying to search for blood. Now, the General Assembly is in the process of making changes to this right now. I can't tell you the number of phone calls I've had this week trying to gear up for March 1st and figure out what it is that we're supposed to do. And the question was, how are we going to be able to execute this nighttime, only in the daytime search warrant for Facebook records or something like that? So we're going to talk about that. The General Assembly is changing that. It's got an emergency clause, so the change goes into effect March 1st. More about that in just a second.
Be aware that if you're going to do a search warrant at night and you go to a magistrate without going to a judge, you have to have made reasonable efforts to locate the judge first, right? That's going to make the judges love us all ever so much. But and you have to document what you did in your affidavit to the magistrate saying, yes, I tried to find Judge Smith, but I couldn't, and now I'm in front of you.
I called him and he didn't answer his phone. I called him 3 times and he didn't answer his phone. I texted him. I texted the Commonwealth. I don't know. You
Yeah.
gotta document, and not just document, but put it in your affidavit.
Yeah. And if you don't do that, well, then your warrant's no good, or at least it's not, what you find is not going to be admissible in a Virginia court.
It can be suppressed.
Yep.
And will be suppressed.
Yep.
Under the old rule, suppression of evidence like this happened when there was the defendant's rights being violated by law enforcement. Inadvertent clerical errors were no basis for suppression. So, a violation, a purposeful violation, that was the old rule. Under this new rule, it doesn't matter if you intended to mess up or violate his rights or not. If you obtain evidence from the search warrant that was in violation of this statute, it shall not be admitted.
That's going to make for a lot of fun fighting it out in court.
But, though, Ken, you'll note that the law doesn't prohibit warrantless searches of private areas based upon consent or exigent circumstances.
It's true.
So let's talk about these amendments. During this session, the 2021 General Assembly session, that is anticipated to end tomorrow on Saturday, the important change happens to 192-56, all the things that we've been talking about. Pending the governor's approval, and I'm told he will sign it today, tomorrow, or Sunday, it has an emergency clause, which means that these changes go into effect March the 1st. What that means is we are reasonably confident that this will become law. And assuming that the amended law is signed by the governor, the law applies to search warrants. What we've all been talking about, nighttime searches, only is going to apply to search warrants of the quote-unquote places of abode. Any place of abode. And it's defined in the amended language of the statute as a dwelling place where the person lives or resides, for instance, a home, a habitation, a place of dwelling, a residence, a living space, an apartment, an RV, a trailer, a mobile home, a hotel room, etc. Any place a person is staying. Even a tent might qualify.
Going over it all again, let's kind of run through this again. There's basically 7 rules you got to make sure you follow if you're doing search warrants under the new laws. First of all, no knocks. You can't do a no knock at all. You're going to have to knock, announce yourself, be in uniform, etc.
Okay, the second deal is the daytime requirement. And under the newly amended language, right, the original version of this that goes into effect March 1st said daytime, and it didn't really define what daytime was. Under the newly amended version that takes effect March 1st, if the governor signs it by midnight on the 28th, it is amended to say between 8 a.m. and 5 p.m. So that gives a little bit of a definition, a little bit better definition of what is daytime.
That'll fix a lot of the problems with it. Okay, now other exceptions to the daytime requirement. If you're going to do a nighttime one, you're going to have to show good cause, and the judge is going to have to agree. He's going to have to authorize this. Now, they don't really define good cause to a legal standard, right? Mm-hmm. We don't know whether this is probable cause, preponderance of the evidence, whatever. Right. That'll be hashed out as time goes along. Most likely, I think, probable cause.
Sure.
But, the judge is going to have to authorize it. And if it's issued after 5 p.m., it's going to... Well, you're going to have good cause as to why it had to be issued after 5 p.m.
And if the search warrant is issued by that judge or anyone prior to you getting it, right? So a lot of people have asked me this. What happens? Do I have to stop our search at 5 p.m.? And the answer is no. If you have secured a location before 5 p.m., and gotten your search warrant before 5 p.m., and you've stayed there or had somebody posted at the door or whatever without interruption until the judge signs off or the magistrate signs off on that warrant, well, then you can go ahead and execute your search warrant after dark. It's okay, provided that you secured it ahead of time. Okay. You also have to be in uniform, and I've had at least 1 or 2 calls about this. An executing officer must be recognizable and identifiable as a uniformed police officer, law enforcement officer. Under 192-78, this means dressed in such uniform as he may customarily wear in the performance of his duties, which clearly show him as an officer of the law based upon casual observation. So note, there's a case, a Court of Appeals case, that says a vest with the words police written on the front of it is not going to be enough to be quote unquote dressed in uniform. You can't wear plain clothes and have a badge around your neck and say, I was dressed in my uniform because I'm an officer that just wears jeans and a t-shirt. You can't say that. It must actually be a uniform. If an officer, let's say a DTF officer or someone, is trying to execute a search warrant of a residence, the best case scenario would be to take a uniformed officer with them to at least go in the door until it can be, you can go and do the rest of it.
Okay, and for number 5, you have to provide an audible notice. Prior to executing a search warrant, uniformed officer, obviously, and that means, as we've said previously, that's somebody in a uniform, not in, not wearing just a vest or not just having a badge hanging off their neck. Have to announce who you are, announce your authority, state while you're there, we're here to serve a search warrant. You can't whisper.
What did you say, kid?
Yeah, exactly. Now, that's not exactly written into the statute, but that's just common sense, right? And we've all seen videos where people tried to get around to going, police here. No, that's not going to work with this. You're going to have to give audible notice. Now, after you've given audible notice and you had that officers in uniform, I don't think everybody has to be in uniform, but you best have your at least couple, 2, 3 at the front, best be in uniform, so it's obvious. And then you secure the premises. You can do a protective sweep, a buoy type sweep, right? Protective sweep so that you can make sure nobody's there who's going to hurt you or any other officers while they're doing the search.
Right. And then we've already kind of talked about giving the search warrant to the person who owns the place and reading it, or if the owner's not present, to somebody, an occupant in there, or if it's unoccupied, where you have to leave it. Now, of all of these 7 rules, there's something that is very, very important, and we touched on it, but that is that if you don't follow the rules, any evidence of the search is inadmissible. It's not admissible in court. You might as well not be doing it. And it's very important as well. As we move to the next slide, you've got to document your compliance. Now, obviously, most of us wear body cams as you go in, and that's important to have that because that'll tell the tale. We all know that sometimes the body cameras malfunction, or you thought it was recording and it didn't. And the last thing you want to do is rely on the body camera and it not work, and then you have no documentation that you followed those 7 rules somehow. So document exactly what steps you took in writing, in your file, so that any future questioning by a defense attorney in court won't undermine the authority of the police work that you've done there and the admissibility of the evidence. So finally, again, assuming the governor signs the law, this is only going to apply to homes. If the governor does not, for whatever reason, sign it before Monday, then it will apply to everything. Homes, businesses, medical providers, phones, digital devices, telecom, internet. So that's why it's going to be signed. Okay? You're hired, right, Ken?
I hope.
Standards and procedures for hiring. Now, we're going to kind of go through this pretty quick because most of it is regulatory. Most of it is Department of Criminal Justice Services adopting professional standards applicable to all certified law enforcement officers and certified jail officers, and having a due process certification process based upon conduct or misconduct and standards, and etc. Right? This is now codified in statute or directed to DCJS to adopt regulations that would have certain criteria as officers are being hired. One of those things that is provided in the new statute is that a hiring law enforcement agency or a jail may require or coordinate a candidate for a potential job for employment to undergo a psychological examination subsequent to a conditional offer of employment or conducted under regular supervision of a licensed psychiatrist or whatever. And DCJS establishes after this a process for that to be. You've heard a lot of debate and discussion about this. Most likely, the General Assembly passed a Citizen Review Board standard under 9.1-601. For local law enforcement, there will be a civilian oversight body that might be possible. Now, it is not mandated. It doesn't have to happen. Your particular locality are the ones who can create this, right? So the Board of Supervisors or the City Council or the Town Council would have to say, we want to have a Citizen Review Board. And just to make sure we're clear, the Citizen Review Boards, I call them Citizen or Civilian Review Boards. They're the same terms are used. But they can do a whole lot, and there's a lot that they can do. Besides just issue findings on complaints, they can make recommendations for charging, policies, practices, procedures, etc. Hopefully we won't have to worry about any of this. Another thing that is required under the new law is a compulsory training aspect, and that is that the Department of Criminal Justice Services is going to establish these training guidelines that your bosses are going to tell you that you have to watch. One of those is a training on systemic and individual racism and the potential for bias-based policing. You've got to go through these. You also have to have training on de-escalation techniques, and you also have to have training on use of force, lawful use of deadly force, etc. And that's all going to be coordinated by your employer. I know most of law enforcement agencies in Wise County already have this kind of training.
Okay, so now next thing they're going to get into is data collection. This really isn't going to affect you so much on the street, except you're going to have to report what you did.
It's documents.
This is going to be your bosses putting it all together to turn it in. So here we go. Now,
was it last General Assembly session? I believe it was, that they put in place some requirements that law enforcement officers are supposed to document certain things. Every time you stop a vehicle, if you give them a warning, you got to document it. If you write them a ticket, you got to document it.
It was pretty bulky and cumbersome.
And now they just made it even more bulky and cumbersome because they've added additional data that you're supposed to report. And that report has to not only be written down and filed with DCJS, and it includes stop and frisks, it includes detentions, etc. All of that becomes effective July 1st. So you got some time to get this straight and make sure you get the information right. But it's going to be a lot, and there are forms that DCJS apparently is going to issue and put together. So I would advise you to check with your boss and make sure that you're good with your chief or the sheriff, and make sure you know what you're doing on that. Data collection also, which is even more interesting, this data is now by code required to be posted online on some kind of community police reporting database or website maintained by the chief of police, or on any other website on which the chief of police generally posts information that's available to the public. Ken, would this include Facebook posts?
Well, I know several departments don't actually have their own.
I know.
So that'd be it.
So again, this part of it's going to be effective July 1st. You've got a little bit more time than till Monday to figure this out, but this can be an issue that they're kind of setting you up for a gotcha moment. So I would advise everybody to kind of watch out for this and get to working on this part of it. And now we come time to talk about the great dumpster fire of 2021, and that is the criminal procedure changes that go into effect for some of them July 1st, some of them on Monday. Let's first of all, Ken, talk about jury sentencing. And there is an amendment to the process for which we have jury trials. Obviously, we're not having jury trials in Wise County right now because of the pandemic and the Supreme Court's emergency order. But when we do have juries, Ken, no more sentencing.
Well, no more sentencing by the jury.
Right. It's judge only unless the defendant wants the jury to sentence, which won't happen.
Right.
This is going to eliminate the possibility that the Commonwealth would request a jury to determine the sentence. Under current law, if you go to a jury, the jury must determine the sentence. But now, bench trial, judge sentencing. Jury trial, judge sentencing, unless the defendant wants a jury. This law will become effective July 1st of 2021. And of course, the judge is required to consider the sentencing guidelines for the particular case. I anticipate this will mean, Ken, a lot more new jury trials, a lot of jury trials.
I think that the defense attorneys will, at least at the beginning, be scheduling and trying a lot more juries until the system kind of figures out how we're going to deal with all this.
Right. Among those things, there's also a couple little things. We can glaze through some of this. This is the access to records part. In order to comply with our duties under Brady-Giglio or whatever, the law now requires that every chief law enforcement officer provide a copy of any reports, disciplinary reports, police reports, internal affairs investigation reports, whatever it might be, to the Commonwealth's attorney. Basically, it's a way to force the Commonwealth attorney to not say we don't have those records as a reason why, if the defense attorney wants it, that they get it, if that makes sense. Finally, in this section of the law, there's the discretion that's written into the code for a Commonwealth's attorney to defer dispositions. We already do this in certain circumstances, but an individual is charged with a particular crime and we want to give them an opportunity to get their life right. They get a year to do it, and if so, their case is either reduced or dismissed. This just gives the statutory authority to do that, Ken. So,
okay. Well, now we've gotten the criminal offenses. Now, they didn't really change a whole lot on actual crimes. Right. A lot of it was procedural stuff, and a whole bunch of it was how y'all are going to live your daily lives doing your jobs. So let's kind of start down the path.
Well, as they continue to decriminalize and potentially even legalize marijuana, now the new law allows you to prepay a marijuana ticket, just as you would a speeding ticket.
Yep. Next thing, false report of a hate crime. Now, we all know that false report or false summoning of an officer, those are both under the statute, whether it's a report or just summoning an officer falsely.
That's class 1
class 1 misdemeanor. Well, now if you do it under any of the things that the General Assembly has determined are special categories, race, religious conviction, gender, disability, gender identity, sexual orientation, color, or national origin, pretty much for any identifying characteristic of a person, if you do it because of that identity characteristic, you've committed a class 6 felony. So something to keep in mind on.
Carnal knowledge of a detainee under 18.2-64.2 is already illegal, but now, under certain categories, if that law enforcement official has carnal knowledge with a person under their custody, arrested, detained by them, including inmates, arrestees, etc., even probationers by probation officers, right? That is a class 6 felony now, not a misdemeanor. Law enforcement officer under this term is the same as defined and elsewhere in the code as under 9.1 as 101. And then finally, as we're talking about criminal reforms, one of those code sections is the code section that we've all been living under over the last year, and that is during the governor's time for announcing that there is an emergency, he can issue certain executive orders to protect quote-unquote public health. And if he issues those emergencies, as we've seen in the last year, and says no gathering of persons of 10 or more, that has been a class 1 misdemeanor. Well, the General Assembly has also allowed for it to not only be a class 1 misdemeanor, it might, there's an or here, it could be just a civil penalty of $500. So you as an officer kind of have a little bit of discretion. I don't know that we've even seen one of these during the past year, but it's there.
Didn't the governor declare we weren't going to do any of these as criminal?
Right. Well, so he says they're a crime, but we're not going to do them as a crime.
Yeah.
Okay. This also has an expiration date, so the law is in effect on Monday, but goes out of fashion. It no longer is a possibility that you can't do this on June 30th of 2023. Let's talk about sentencing changes and early release. Among the things that the General Assembly is trying to do is to decrease the prison population. And the Department of Corrections already has the Earned Sentence Credit Program. We all are aware of that. In 1995, when parole was abolished, the General Assembly established the truth in sentencing system, which means if an individual gets 10 years, they do 10 years. They have the option to get, under current law, 15% off their sentence if they're a good boy, if they earn credit to their sentence by participating in programs, by behaving, whatever it might be. And that gives the Department of Corrections the discretion to change their sentences downward by 15%. So they do 85% for a felony, 50% for a misdemeanor. Under this new system that's going to be expanding July 1st of 2022, and it is going to be retroactive, by the way, folks. It is going to apply for everybody already sentenced. So under this new system, to begin next year, July 1st of 2022, we're going to have some rules changing. Inmates can earn credits based upon their behavior and cooperation with programs while incarcerated. Again, the Earned Sentence Credit Program. They can have anywhere from 0 to 15 days taken off of their sentence for the first 30 days, and they can have a bunch of other stuff. Now, this can be a little bit confusing, Ken. As we move forward to the next slide, it will kind of lay this out a little bit more. There's going to be a 4-classification system. Level 1 gets 50%. Level 2 gets 75%. Level 3 gets 88%, and Level 4 has to serve 100% of their sentence. And the point of this, basically, Ken, is that just about every single person who's sentenced to a crime in Virginia is going to get the 50%, unless you fall into a certain category under subsection A of that statute, 53.1, which is 202.3. We've got a form that we will send to you if you're interested, that helps you understand this. Certain things like murder are going to be under the 85% category by statute.
Right. Effectively, there's 5 levels. Although they only put 4 in the statute, there's going to be, level 1, which is what most everybody's going to be, is they're going to serve 50% of their sentence. And then we're going to move up. If they do stupid things while they're in jail, prison, they'll fall into these other levels as punishment.
Now, the thing that's interesting about this is the Department of Corrections, while they have discretion to change an inmate from 50% to, say, 75% because they misbehaved, everyone starts out at a level 1. So everyone, once they start, are a 50%er. And if DOC wants to change your classification, you refuse to take programs or you spit on the corrections officers, whatever it might be, they have to give you a hearing as an inmate, a hearing before a panel, and you've got appeal rights and on and on and on. So I don't know how this is actually going to play out, but what I anticipate is that it's going to be so difficult to move someone from a level 1 to a level 2, etc., that most people will stay at a level 1, and they're just going to move people to different levels that are really, really, really misbehaving. I don't know that to be the case, but that's just a hunch. Again, it doesn't go into effect till next year because DOC is directed to come up with a whole bunch of new programs to make sure that inmates do what the General Assembly wants them to do. Take classes, earn GEDs, all of that. Okay? Right.
But to be clear, there are a number of violent crimes that are 85%. We've seen this in other states. Sure. Kentucky does this.
Okay.
Yeah, so that's what we're going to end up with.
To help you understand this better, we have put together a link here, and it's a link in the slides. We will send that particular document out to your department for you to review. If you don't get it, feel free to email me or Ken, and we can send you that document. It's a 3-page document that hopefully helps you understand it. And while we're in the business of letting people out early, 53.1-40.2, or 02, is the terminally ill inmate statute. And this allows for a conditional release of any inmate who is deemed to be, quote-unquote, terminally ill. Who's making that determination?
Who knows?
The Department of Corrections, I guess.
Yeah.
And the parole board. So they can petition and be eligible for release by the parole board early.
Well, of course, as I always say here, more's coming, folks.
Let's go over a couple of things just to make your head completely spin. And these are things that have passed. We're just waiting on the governor to sign and figure out the final language of them. And just so that you can see what we're talking about that isn't the law yet, but probably will be in July. Freedom of Information Act will apply to all criminal files, documents, photos, body cameras, etc. Marijuana will be potentially legalized. They're going to permit a defendant to introduce potentially mental condition as a mitigation of guilt. There's going to be a limitation on what we can do with probation violations and how long we can put a person on probation. There's a repeal of the statute that's a presumption against bail. That's already passed. Automatic expungement or sealing of past criminal conduct and convictions. The elimination of most, if not all, mandatory minimums. The restructuring of the robbery statute to right now it's everything is life. If you a maximum punishment of life, there's going to be different degrees of robbery, like a first degree robbery, a second degree robbery, and different punishment based upon the different categories. Assault on law enforcement officer is also going to change, and we will go through that later. Third or subsequent larceny will no longer be a felony if it goes through. And finally, we've all seen the news and heard about the repeal of the death penalty. Again, these are things that are just pending. Now, as we end our presentation, we've gone for a while, and I thank you so much for listening. If you've got questions, feel free to call or email or reach out to anybody at the Commonwealth Attorney's Office. We are here to serve you. I know we've kind of run through this quickly, Ken, and I know that there's a lot here, and it makes your head spin.
Yeah.
And naturally, we don't write the laws. We have to figure out how to enforce them, and we do our best to keep the public safe in the meantime. And I know you, as a law enforcement officer, work very hard to protect us. And these rules, many of them make your life, your job more difficult. And for that, I'm sorry. And I hate that. And our office is here to support you. But what we've got to do is we've got to live with this new framework, and we're going to do the best we can to figure out what it is and continue to protect our community. And I thank you for not losing faith and not being discouraged through all of this. So call us, email us if you've got questions, if you've got comments, if you just want to throw the books like Ken did here in this photo. Go for it.
And we'll be back in a couple months telling you what new and wonderful things the General Assembly's done this time.
Thanks so much for watching, folks, and God bless you. Thank you for all you do.
Yeah, I can pause so we can do that. That's
So
not a
yeah,
problem.
so then it'll be one continuous. Hey friends, I'm Chuck Slemp, Commonwealth Attorney for Wise County and the City of Norton.
And I'm Ken Lammers, Assistant Commonwealth Attorney, and we're here to do a legal update from the last special session.
As always, if you've got any questions about anything that we talk about today, you can email or call either of us. Our email addresses are on the screen as we go through some of these new updates.
So let's get started.